Welcome, everyone. My name is Carol Watts, and I am the president of the League of Women Voters of San Jose, Santa Clara. And we host our Lunch with League on the third Thursday of most months of the year. And we have conversations with people who affect our lives. Today, we're so pleased to welcome Judge LaDoris Cordell to speak with us. She is well known in our community as a municipal and superior court judge and has recently written a book about that experience titled Her Honor. But before we introduce her, I warmly welcome so many attendees to our virtual luncheon today. We hope you have your brown bags. We have league members from all over the Bay Area and the state, and also lots of friends. The League of Women Voters was founded in 1920, when women were finally granted the right to vote by the 19th Amendment after decades of fighting for that right. We warmly welcome everyone, including men, to join our nonpartisan political organization, which encourages informed and active participation in government and influences public policy through education and advocacy. We do not support or oppose any political party or candidate. This year is an election year, so you will begin hearing about our strong efforts to get people registered to vote, to learn about the candidates running for office and about measures on the ballot. And we would love your help in this important effort. If you're not a member, we urge you to join our organization. Just go to the web address being posted in chat in just a minute, and to find your local league. You can filter by county name to help narrow the choices. Most people join the league that serves their city, but you can join any league. Our league serves San Jose, Santa Clara, Milpitas, Morgan Hill, and Gilroy. For more information about us, go to lwvsjsc.org. But today, I am so honored to present our host, our guest, Judge LaDoris Cordell. Many of you already know some of her great accomplishments, and you're going to hear more as we go on. In 1971, she graduated from college with a degree in drama and speech. And 3 years later, she graduated from Stanford Law School. My personal take is that her drama degree has served her well. Not only do people in public life, like a judge, need to be able to express themselves well so that people will listen to them, but I'll bet she also drew on this background when she did the audio recording of her new book, Her Honor, published last October. I listened to this entire book and was absolutely entranced to be listening to the author candidly tell her own story. In addition to you're going to hear more about all of her. I'm not going to go through all of her accomplishments, but a couple of things I thought were interesting. She co-founded the African American Composer Initiative, and that mission is to bring the music of Black composers past and present to the world. And she is a vocalist, pianist, and artist. She's been interviewed by many people like New York Times columnist David Brooks, Billie Jean King, Professor Anita Hill, Amy Goodman, and Leslie Stahl, to name just a few. But now it is our turn to hear her words of wisdom. Welcome, Judge LaDoris Cordell.
Thank you so much, Carol, and thank to all of you members of the league, non-members who I hope will become members, for participating in this luncheon, and I'm delighted to be here. I'm going to take a little bit of time to talk about our legal system, and as I talk about it in my book, as Carol noted, this book is just out and it's called Her Honor, and My Life on the Bench, What Works, What's Broken, and How to Change It. And in doing so, I'm going to be talking about some issues that I believe will be of interest to those of you in the league about how we can make our legal system far better than what it is. So let me just start quickly with the writing process. I had no thoughts about writing a book the whole time I was on the bench. But what I did the last 8 years I was on the bench, and I can't remember what started it, but I decided to write letters to my parents every Friday. And I did that for 8 years. And I would write about everything that happened that week in the court, about the cases, the rulings I made, but also about how I felt when I had to make decisions, sometimes decisions that I did not actually want to make. So if I have a photo I'd like you to see of my parents, because without those letters, I could not have written a book. And that's my mother and father, Clara and Lewis Hazard. They're no longer with us. And sadly, they're not here to see the book, but their spirit is infused throughout the book. The purpose of my book is to educate readers about our legal system, to entertain. This is not a heavy textbook. It's a book about stories of what happened when I was in my court. And the purpose is to energize readers to fix many of the broken parts. So I call this genre a primoire because it's part primer about the legal system and part memoir informed with my own experiences. There are 9 US Supreme Court justices, and they hear about 80 new cases a year. For nearly 20 years, I was a state trial court judge. There are about 30,000 of us, and in these courts, each year, about 80 million new cases are filed. So Her Honor is a book about the world of state trial court judges. State trial court judges preside over what I call the people's court, because these judges are on the front lines of our legal system. They're the first judges that anyone encounters when they first come into our state court system. And the cases that trial court judges preside over touch every part of our lives, covering subjects such as adult, criminal, and juvenile criminal cases, dependency cases, and that's involving children who've been neglected and or abused, where judges decide where they should be placed or what happens to them. Family court cases that include divorces, child custody, child support, pet custody, yes, even pet support. Adoptions, name changes, probate, where people fight over the spoils of their dearly departed, conservatorships, think Britney Spears, drunk driving cases, mental health cases, where judges decide if individuals involuntarily confined in locked psychiatric units can be released, traffic court cases, and small claims cases, and that's like Judge Judy cases without any lawyers. I presided over all of these cases, these kinds of cases, because I was an all-purpose judge. There's some judges that stick with just one thing they want to do. I wanted to learn it all. And so I presided all of these, and I write about all these various subjects in the book. One thing I want to make sure people understand that judges there are state court judges who preside on our appellate courts. And what they do is they review decisions of the trial judges. And those appellate judges, they can take days, weeks, and months, 6 months or more to reflect before issuing their decisions. But trial court judges, we get 6 minutes maybe. And as I note in the book, the pressures on state trial court judges are constant and they are intense. So Her Honor is packed with information about these various subjects. The book is for legal and non-legal people alike. The endnotes and the appendix are not in the book, they are online. And I want to start off now just telling about how I even got into judging. The first chapter of the book is called Bitten by the Judge Bug. And in it, I tell a story about how I never even thought about being a judge until I got a phone call from a stranger. And his name was Mark Thomas. And he was a white guy, this guy who was a judge on the court in Santa Clara County, who called me when I was an assistant dean at Stanford Law School. And he said, look, I'm trying to add more people of color and more women to our Judge Pro Tem program. And could I put your name on the list? A Judge Pro Tem program, some courts have them, Santa Clara County have them, where it gives a chance for lawyers who have practiced law for a certain period of time can come and sit and be a judge for a day and preside over a small claims case. And Judge Thomas was trying to just open up the doors to get more people from various backgrounds interested in judging. So I agreed. He put my name on the list, and then I forgot about it. As I write in the book, I got a call a few months later saying my name had come up. It was kind of a random thing on the list. And I went to court, got a robe, and presided over a case that changed my life and got me thinking about becoming a judge. And let me just give you a little teaser. It's a case about hair, H-A-I-R, about hair. So after that experience, it took a couple more years, and I was appointed to the bench in 1982 by then Governor Jerry Brown. If you could put the picture up, and I was sworn in at Stanford Law School. And here you can see this is 1982. My parents are there, my two daughters and my now ex-husband, my then spouse. My daughters now are in their 40s, just so you can get an idea of this. And the next one, if you'll put that up, and it shows me actually being sworn in by Judge Felton Henderson. If we can get the next one there. And he went on to become he was a federal judge at the time and has since retired. So because there are way too many subjects to cover in the time that we have, I've chosen 3 subjects that I would like to talk to you all about because I think they're of interest specifically to members of the League. And the 3 subjects I want to talk about are juries, judicial elections, and judicial independence. And after that, I hope we can have a conversation. First, juries. Juries are all over the news lately. The jury trial of Kim Potter, the police officer who yelled "taser, taser," and then mistakenly fired her gun, killing unarmed Daunte Wright, a young Black man. The jury trial of Elizabeth Holmes, who bamboozled investors with her magical claims about her company, Theranos. The jury trial of business of Ms. Maxwell, the aider and abettor of child predator Jeffrey Epstein. Well, I presided over dozens of jury trials during my time on the bench involving all manner of crimes as well as civil cases where people are suing each other over money. The right to a jury trial is enshrined in 3 places in the U.S. Constitution. Article 3, the 6th Amendment, speedy trial in criminal cases, which is mandatory for all the states, and the 7th Amendment, which says you have a right to civil trials, but that's optional for the states, although all of the states requires trials, jury trials, they allow them in civil trials. I love jury trials because I'm a people person, and I saw these trials as a way to introduce people to our legal system and the hope that jurors would have a good experience and feel confident in the system. Jury selection I found fascinating, amusing, and annoying when people who saw jury service akin to the plague did their best to get out of jury duty. And I'm hoping that many of you have had a chance to serve on a jury. And it's my hope that if you have, you found it to be a positive experience. However, I can understand why many would avoid jury duty like the plague. I read from my book. Why do so many people dread serving on juries? It's my guess the answer lies in the inordinate amount of time wasted sitting around waiting to find out which of those summoned will be chosen. As a consequence, most people come to view jury duty as a nuisance and an inconvenience. It frequently is. Also, it doesn't help that compensation for each day of jury duty, the time waiting in the jury room during jury selection and actual jury service, is a pittance. Juror fees range from a high of $50 per day to $5 a day to nothing and everything in between. So I believe that if we as trial judges believe that juries matter, and they do because they maintain the integrity of our system, I believe that jurors should be adequately compensated. California compensates jurors at the grand total of $15 a day, and that doesn't include the very first day of jury service. We need to do better. In the next chapter of my book called The Fix, I propose 10 ways in which our legal system can be made better. And in The Fix, I propose that the states establish jury funds to adequately compensate jurors. So you can get more information on that as I talk in more detail about it in the book. In the book, I note that one aspect of jury selection that is particularly troubling is the use of peremptory challenges. And it isn't only me. In 1989, Justice Thurgood Marshall called peremptory challenges, and I quote, "perhaps the greatest embarrassment in the administration of our criminal justice system." Peremptory challenges allow each side in a criminal or civil case to excuse potential jurors for any reason or for no reason at all, as long as they have not been removed because of their race, gender, sexual orientation, or religion. And each side gets a defined number of these challenges. In 1986, the U.S. Supreme Court issued a ruling in the case of Batson versus Kentucky, which I describe in some detail in the book. And basically, under Batson, When a defendant contends that the prosecutor's peremptory challenge was racially motivated or motivated by other types of discrimination, the prosecutor has to offer to the judge a neutral explanation for removing the prospective juror. And then it's up to the judge to determine if that explanation is plausible. How has that worked out? Not well. More than 30 years after Batson, trial judges accept superficial and outright ridiculous race-neutral excuses from prosecutors for their peremptory challenges. Here's an example that I have in the book. In 1995, a prosecutor struck two prospective Black jurors because of their mustaches and goatee-type beards, explaining, and I quote, "Those are the only two people on the jury with the facial hair. I don't like the way they looked." The trial judge found the explanation to be race neutral. When the Batson case was decided, Thurgood Marshall was prescient when he wrote, "Merely allowing defendants the opportunity to challenge the racially discriminatory use of peremptory challenges in individual cases will not end the illegitimate use of the peremptory challenge. Any prosecutor can easily assert facially neutral reasons for striking a juror, and trial courts are ill-equipped to second-guess those reasons." So what is to be done? California is leading the way to fixing this problem. And I talk about it in the book, and I'll just read briefly a passage from it as to how we're fixing it. And it goes as follows. California Assemblyman Ash Kalra authored a proposal for a racial justice act that prohibits, and I quote, "prohibits the state from seeking or obtaining a criminal conviction or from imposing a sentence based upon race, ethnicity, or national origin." His bill would require trial judges to hold evidentiary hearings when it is claimed that racial bias was a factor in a criminal trial or in sentencing. The act also makes it a violation if race, ethnicity, or national origin was a factor in the exercise of peremptory challenges, whether or not purposeful. As importantly, the legislation gives to judges the ability to remedy the influence of racial bias. So, for example, when peremptory challenges are proven to be racially motivated, judges can reinstate the wrongly excluded juror, declare a mistrial, order a new trial, or continue jury selection with a new jury pool. So Governor Newsom signed the act into law. So California is the first and only state that now has on the books a law that's geared to weeding out racism in our legal system. I don't know if any hearings, for example, on peremptory challenges have been held in the state. We are kind of in a waiting period to see how this is going to go. Prosecutors and trial judges opposed this act, and they opposed it because they said, well, it's just going to clog up the system and it's going to take too long. And the response I give is to do justice takes time. So we'll see how it all works out. Next, I want to talk about judicial elections, a subject I think dear to the hearts of League members. As many of you know, I was able to secure a seat on the Superior Court as a result of a countywide election in 1988. In my book, the chapter is called Judges for Sale, where I describe that experience about my own election, and I describe how the elections of state court judges work throughout the country. If you could show the image of my being sworn in, and here's a picture, was in the newspaper, of Judge Peter Stone high-fiving me after I'd taken the oath and been elected to the Superior Court in 1988. I want to show quickly the next slide, and it's really a look at me through the years. So the 20 years that I'm on the bench, and I wrote about, I said hair in the first chapter, but hair was a part of my identity and it changed over the course of the years. So the very bottom middle picture, you can see how my hair was straightened and kind of fluffed out there. And eventually on the far left, your far left, you see I had little dreadlocks and I had a box and short hair. So it was an important part of my identity. Okay, so moving on. So to be clear, there are no federal elections of judges because they are appointed for life by the president. Judicial elections were first, state judicial elections were first instituted in the late 1770s and early 1800s when the territory of Vermont, it was not a state yet, and the states of Georgia and Indiana used them to fill seats on their lower courts. In 1832, Mississippi became the first state to adopt judicial elections for all of its judges. In the rest of the states, governors appointed judges to lifetime terms during what they called good behavior. So again, reading from my book about the elections. And let's see. And actually, to save a little bit of time, I'm going to kind of skip over that. When I ran for election, I raised $70,000 primarily from donations by about 800 lawyers. And it's really a pittance compared to today's judicial races. And I want to just give you a sense about what we're talking about. Let's see, by 2004, candidates backed by the biggest spenders, the business community, won seats in 12 of 13 state Supreme Court races. And after the 2010 US Supreme Court decision in Citizens United allowed an unlimited flow of money into political campaigns, the floodgates to state judges' campaigns opened as well. Now, I want to read one further section I think is a real mind blower here. If you've not heard of it, you should become aware of the Brennan Center, which is this Brennan Center for Justice in New York. So that center analyzed 15 years of television advertising data, again, reading from the book, for state Supreme Court elections to gauge the ads' impact on judicial decision-making in criminal cases. Generally, the ads attack judges for being soft on crime or praise them as tough on crime. Now, there were three findings. The more frequently ads aired during an election, the less likely state Supreme Court justices were to rule in favor of criminal defendants. 2, closer to their re-elections, trial judges in Pennsylvania and Washington sentenced defendants convicted of serious felonies to longer sentences than normally imposed for those crimes. And 3, trial judges in Alabama impose death sentences more often in election years, sometimes overriding life sentence verdicts handed down by juries. Judges are not politicians. I have to tell people this a lot. Politicians make promises to voters to appeal to whatever it is that their constituencies want. Unlike politicians, judges are independent. The only promise that judges can make is to adhere to the rule of law, adhere to legal principles, and adhere to constitutional precedent. Judges are held accountable by appellate courts who review their rulings and their decisions, by disciplinary commissions, and by properly run recall elections. It is my view that judicial elections should be replaced with independent nominating commissions that are bipartisan, appointed by diverse stakeholders, include non-lawyers, and have clear criteria for vetting candidates. The nominating process should be open and transparent with publicly available data about the diversity of applicants and the nominees. And reading just a bit from my book, a little more, see if I can find that one. If not, I will just kind of leave it alone. Okay, I think I'll leave it. So here's what I believe. And again, this is part of it is in the fix. We need to do a better job of educating voters about judges. I can't tell you how many times I've gotten late night phone calls from neighbors asking me who they should vote for in judicial races. We need meaningful voter guides that include detailed profiles of the judicial candidates, including any of the results of evaluations by lawyers that are occasionally conducted by the courts. And again, this is assuming we continue with judicial elections. I think we should do away with them. I also think that as long as we have judicial elections, that lawyers seeking appointments to the bench should be required to audition for the job by serving as judges pro tem, the way that I did when I had that chance to serve for a day, so that they could be evaluated by nominating commission members. Again, more detail on that when we talk or also in the fix. Okay, last topic, judicial independence. In 2016, Judge Aaron Persky presided over the criminal trial of a 19-year-old Stanford freshman who was charged with sexual assault of a 22-year-old woman who was a college graduate. Both were at a fraternity party and both were highly intoxicated. A jury convicted the student who, before he was even charged with a crime, had been expelled from Stanford. After Judge Persky sentenced the student to 6 months in jail, the recommended sentence by the probation department, all hell broke loose. He became the target of a recall campaign coordinated by a female Stanford law professor, outraged that the judge had not imposed a harsher period of incarceration. She wanted prison time. What the recall deliberately ignored was that the punishment handed down by Judge Persky was actually very harsh because it included an order that this student, this 19-year-old, be required to register as a sex offender for the rest of his life. Now, I want you to consider that convicted murderers who have served their sentences are not required to register as murderers for the rest of their lives. They don't register as anything. The student's punishment was harsher than that of someone who had taken someone's life. Before the recall was over, the name Persky would become infamous throughout the country and beyond. Recalls of judges, I write about this in the book, are unique to the states. Federal judges cannot be recalled, no matter how controversial their decisions. The California Constitution allows for the recall of elective officers, including judges. All that is needed is to collect the required number of signatures of registered voters to place a recall on the ballot. And the recall can be for no reason at all. Simply put, disagree with a judge's ruling, and she can be targeted for recall, even when the ruling is entirely lawful. I became a spokesperson on Judge Persky's behalf in opposing the recall. I spoke up because the recall lied about his track record, because the sentence he imposed was within his discretion and entirely lawful, and because the judge was not legally permitted to speak about the case. And most importantly, I spoke out because the recall posed a threat to judicial independence. And I read this quickly now from the book. It is one thing to recall a judge for an act of malfeasance, but it is quite another to recall a judge for making a lawful decision that we don't like. Think about it. Judges take an oath to defend and to bear true faith and allegiance to the Constitution. But today a judge can lose her job if in defending the Constitution and bearing true faith and allegiance to it, she renders a decision that happens to be controversial. Putting the judicial finger to the wind to gauge public opinion is fast becoming the standard for judicial decision-making. And when that happens, when the cacophony of the mob determines how judges decide their cases, our independent judiciary becomes our dependent judiciary. So, what are we to do? How do we ensure that our state court judges maintain their independence? This is a serious issue because if we lose our independent judiciary, we lose our already fragile democracy. The answer that I propose in the fix is to strictly limit judicial recalls to instances of judicial malfeasance or failure to perform the duties of the office, or to judges who have been convicted of serious crimes. That's the way it is done in Georgia and Montana. Recalls of judges in those two states can never be based on a judge's lawful decision, be it discretionary or mandated by law, no matter how controversial. The revision of California's recall system would require an amendment to the California Constitution. And if our legislators won't take the lead in changing the laws, then we, the people, the voters, must do it using the initiative process. I cannot close without touching upon the subject of race, which not surprisingly runs throughout the book. Now, here are two short passages from the book on this subject. Okay. Race has always been the elephant in the courtroom. I recall suggesting, I'm going to skip that section. Let me start again. Race has always been the elephant in the courtroom. With the murder of George Floyd in May 2020 and the dramatic rise of the Black Lives Matter movement, racial disparities, long apparent in criminal prosecutions, sentencings, and incarcerations across the country, are finally front and center in the public discourse. The elephant has exited the courtroom and entered the world stage, giving to judges not only permission, but also the obligation to call out the legal system's failings. And then one other passage I want to read to you very quickly, and then I will close. My tenure on the criminal court bench was a conflicted one. By simply donning my robe, I knew that I lent legitimacy to a system that disproportionately targeted people of color. The majority of cases over which I presided involved defendants who looked like me. My presence on the bench gave defendants of color hope that they would be seen not as a bunch of gangbangers, thugs, and drug addicts, but as human beings. And it would allow for the possibility that many, perhaps most, were better than the worst crimes they had ever committed. One of my life's sad recognitions is that it is far easier to understand the humanity of even the most egregious of offenders when that person resembles you, less so when she does not. And finally, I want you to understand that there is much that is good about our legal system. The very principles that are the foundation of the system and our nation are the best in the world, such as, that all are created equal and entitled to life, liberty, and the pursuit of happiness, that everyone has the right to a speedy trial, a right to a trial by jury, right against self-incrimination, the right to due process. The problem is in the implementation of these principles. The propertied white men who established these principles, many of whom owned people who look like me, did not contemplate that these principles would apply to women, to poor people, and certainly not to people of color. So our challenge is to ensure that these wonderful principles that underlie our legal system are applied equally and fairly. So in closing, I leave you with just the final sentence, the conclusion of the book. And I say this: judging has been the most fulfilling of my various careers. For nearly 20 years, I wielded power over the lives of people. And for nearly 20 years, I did what I believed to be right. While it is up to the next generation of voters, politicians, activists, lawyers, law professors, and judges to continue to clear the path to a more perfect union, I refuse to give up on our legal system, and I will never give up on our judiciary. Hopefully, neither will you. Thank you.
Thank you so much, Judge Cordell. As I mentioned, I have read the book, and I heard you actually reading the book, as I heard the audiobook, and I strongly recommend it to so many other people. And yes, you have chosen the fixes that I think are of the greatest interest to those of us in the League. The League, by the way, was a co-sponsor of the Racial Justice Act, and we're still very strongly supporting it. And now I'd like to introduce, we're going to enter the Q&A part. I would like to introduce Kathy Muller. And she is the secretary of our board of directors, and she's also serving as the chair of our fundraising committee. She just led the effort to get a grant from the Farrington Historical Foundation to help us do our important election work. And additionally, we have a $10,000 grant from a generous anonymous donor that we will use to match donations made by other people. So if you would like to donate, you can do so from our website, lwdsjsc.org. We had many questions entered when you registered to attend this event, and Kathy will ask those first. You may enter more questions into the Q&A function found near the bottom of your computer screen, and we will do our best to get to them, but we cannot guarantee to do so. Welcome, Kathy.
Thank you, Carol. Thank you, Carol, and thank you so much, Judge Cordell, for your really interesting presentation. Thank you. As Carol mentioned, we did have many questions, and so I think we should just get into them. And maybe a good one to start with is kind of a general question. What is the best route for reforming our justice system, our judicial system? Legislative, ballot measures, or legal challenges to current policies?
Yeah, the answer is all of the above. And by the way, I have a problem, for example, when people call things like our criminal justice system. The justice part, we're not there yet. There's so many parts in our legal system that gets us there. So it's a criminal legal system, which most people are familiar with. It's going to take all of these. And when you read the book and you get to the fix, you will see that I make recommendations in terms of legislation, And that involves everything. For example, I didn't talk about today, but it's in the book about plea bargaining. Most people don't know that 98% of all criminal cases never go to trial. They're plea bargained. And the concern is that many of these plea bargains are coercive. And how do we know this? Because how many thousand people have been exonerated, found not guilty when they pled guilty, or coerced to do so. So there are many things that need to be made right. And the answer is really in the question that you asked, because it covers everything from, voting, going through the legislature, initiatives. There are all kinds of ways that once you decide what you want to focus on in our legal system, to then go there. I'm very concerned about judicial independence, and I'm concerned that we don't know enough about who our judges are and how we select them. And this book, hopefully, when they read it, people will understand how that whole process works. And then we can go about the process of making the judiciary more transparent for everyone.
Thank you. You mentioned as part of your presentation that judges are not politicians, but can politics really be removed from judges' rulings?
That's a good question. If you look at the federal system in the U.S. Supreme Court, it's politics. I mean, that body has become a political body, and I find it very sad. That is not what was intended for the U.S. Supreme Court. So when we get to the judiciary, judges on the state level cannot avoid becoming politicians as long as there are judicial elections. And when you read about some of the examples I give in the book about judges who were elected and judges who were thrown out because of politics, you see how judicial independence is so threatened. In order to take politics out of the judiciary, we have to move from elections entirely. And so I can talk about this because I was elected and I won. And even that being the case, I am not in favor of judicial elections. So these nominating commissions, I think, are the answer. California actually has them. What's called the Jenny Commission, Judicial Nominations and Evaluations Commission, JNE. However, it really operates in secret. People don't even know when they meet. And I think their meetings should be public, that we should be able to live stream them and watch them. And the governor doesn't have to abide by whoever it is the commission's vetted. The governor can just go pick somebody on his or her own, which I think should stop. That we need commissions that reflect our community, that are entirely transparent, and that then send, say, a slate of people who the governor can then select from in order to put on the bench. But it'll be someone that the public is completely aware of.
Okay. Speaking personally, what was one of the most difficult cases or difficult decisions that you had to deal with?
So you have to figure any state trial court judge makes thousands and thousands of decisions. And over a 20-year period, I indeed made probably tens of thousands of decisions. And some were very difficult. I always say about judging, it was the best of all worlds and it was the worst and everything in between. I had really good days and I had some really bad days. The most difficult cases for trial court judges, and me included, are where judges have discretion. And I have a whole chapter in here about judicial discretion where, okay, here's the rules and the guidelines, but you have discretion within them. And that's really the hard part, where you have to use your discretion. Judges are human beings. We have biases. We are informed by our own experiences growing up. I grew up in a Black community. I went to predominantly white public schools. I didn't see many people who looked like me in my classrooms. And yet when I came home, I was in a Black community. The Black church was very important in my upbringing. So I'm informed by my upbringing, my community. And every judge on the bench is so informed and brings their own biases. The hard part is using your discretion and trying to do what's right. And even harder than that, though, are the mandatory minimum laws. This is on the criminal side, where you have to impose a sentence, even though you feel it's not right. And that was the hardest for me. So California had the harshest 3 strikes law, which I think has resulted in the mass incarceration of people of color around the country, because many states have this. And the last case that I remember I handled, and I write about it in the book, is a Black man that I had to sentence to many, many years in prison. It was a life sentence plus like 55 years. He was going to die in prison. I believed that was wrong. But because I had taken an oath to uphold all of the laws, and this was a law in California, I had to impose it. And indeed, after I did that, I decided that I could no longer stay on the bench. And that was really the big impetus for me leaving. And I talk about that in the third to last chapter of the book.
Okay. Well, you alluded in the beginning of that answer to the Supreme Court. And there are a couple of questions with regard to the Supreme Court that we'd love to hear you speak about. Do you think that Supreme Court justices should have term limits? And also maybe, what do you think about expanding the size of the court?
Absolutely to both. Right now, it's a game that's played to see who can outlast whomever for the next party to get in. And it just saddens me. So I do believe there should be term limits, and I think there should be staggered terms for justices on the bench. And I believe that, yes, I think that the court should be a larger court. I'm not an expert on this, but I have read enough to be influenced by those who know about this issue to say that, yes, I think it is time to explore that, because we've gotten so far away from what the court was supposed to be. Now, and understand, I mean, we have had a court of this size for a long time, and we've had a court that, in my view, has reflected America. So it has made some of the worst decisions. Probably the worst one was Plessy versus Ferguson, where the court, and the language of that decision is just stunning, basically said that African Americans are really, have no standing before any court, separate but equal, the way it should be, and we're not even seen as equal. And then we have a flip, where in 1954, we have Brown versus Board of Education that says, no, we're going to undo Plessy. So there have been bad things and good things. And now I'm very concerned about where we're headed in terms of the 6 conservatives on the bench who are absolutely political. And I'm very concerned, one, about, for example, Roe versus Wade. It's, I don't think it's long for us. And we will be looking then to state court judges to really protect rights that are being undermined, I think, by the Supreme Court, which is why it's so important that people read the book and understand what it is state court judges do.
Going back to the first part of your presentation, you talked about juries. You talked about preemptory challenges quite a bit, but is there a better way to select juries?
So I love jury trials. I'm a people person, and I just loved bringing people in, because most people coming in had no clue about the law and about how the system worked. And it's a real opportunity for judges to say to people, you are important, and here's how this legal system works. And of course, one of the issues I raised in talking was we don't pay jurors sufficiently to really make that really have some meaning. Mm-hmm. So no, I don't think that jury selection itself needs to be changed at all. It's a chance for people to talk about how they feel about the system, and the judge is in charge. In a court, the judge is the producer director, gets to decide who gets to speak and who doesn't, but allows lawyers to participate in the whole process. So no, so jury selection's fine. The peremptory challenge is the big problem. And it's on trial judges to stop rubber stamping these ridiculous, quote unquote, race neutral explanations, and to dig deep. And that's what the Racial Justice Act does. It says, judges, you dig deep. And if you believe and find that there's a problem, then you provide the remedy.
Okay, different question. What reforms would you support for the juvenile criminal justice system in the state?
Great. I have a chapter in the book all about juvenile law, and not the dependency side. Dependency is where kids have been abused and neglected. So I'm talking about the criminal side, which is called delinquency. So I have a chapter devoted to this, and I do have in the fix 2 recommendations. So first of all, most people don't know that in juvenile trials, in juvenile court, there are no juries. So it's just the judge. And the US Supreme Court has even said, that's fine. The Supreme Court has basically said, no, we think that judges can do a better job than juries in the juvenile court. Now, If you look at the beginning of juvenile courts, and I write about this in the book, they were there set up differently because juveniles are not adults. Their minds are not fully developed. And the whole point was rehabilitation. We have moved away in this country from the rehabilitation goal and moved more toward punishment. And I think that's sad. And I think because of Black Lives Matter movement and other people speaking out, we're starting to maybe go back to juvenile court being more in terms of rehabilitation. One recommendation fix I make order is that there be the option to allow jury trials in juvenile court. And I believe that juries can do a better job, if not as good as, a better job than judges in where juveniles are charged with felonies. So juveniles charged with felony in juvenile court, because if they're convicted of a felony, that's on their record. There's a felony. And I believe that juries should be an option. And that is an option in several states, not in California. The second recommendation I make is that right now, juveniles can be sentenced to life without the possibility of parole. And that means we've given up on young people when that sentence is imposed. The rule is that the U.S. Supreme Court has says it is within the discretion of a judge to do that. So there can be no mandatory life without the possibility of parole for people convicted of crimes when they were juveniles, but it is discretionary. And in my view, that discretion should be completely taken away from judges. No juvenile should ever be sentenced to life without the possibility of parole. That cannot happen in California. And in California, even juveniles who've been convicted of committing the most egregious of crimes still have the possibility of parole after serving substantial period of time of incarceration. So I believe that should happen across the country.
Good. A question through chat, it just came in through chat, is asks that you discuss today's world compared to when you were first a judge. Are there now more judges of color? And if so, how has this impacted the system?
Yeah. When you increase the diversity of the workplace in any scenario, if it's the corporate world, if it's in education, if it's in the judiciary, you make it a better place. And by diversity, I mean women, people who are LGBTQ, and people of color. The more you bring that diversity in, the better. Why? Because one, judges, for example, interact with one another. Maybe they have lunch together and they learn from each other. And those different perspectives are important. So have things changed? Yes. Now think about it. I mean, not that long ago, 1982, I was the first African-American woman judge in all of Northern California, 1982. Well, since then, yes, so much has changed. We have a diverse judiciary, not diverse enough. It's a work in progress. And what's really changed is TV. I don't know how many of you watch TV, the court shows, but my goodness, there is this plethora of judges of color and women on these TV court shows. I think they're a joke. It's entertainment. It's not the real deal. But at the same time, I mean, it's a real reflection of how our mindsets have changed about seeing people in Black robes, not just being white males. So we are making progress. And I will tell you, the more liberal the governor we have, the more diverse the appointments have been to the bench. So I am delighted with the appointments that Jerry Brown made both times in, and I'm certainly a beneficiary of the time he was in, and certainly of Gavin Newsom as well.
Okay. Again, kind of changing gears. What can we citizens do to change our prison system?
Oh my goodness. The first step is to build fewer prisons. And I listen, and let me just start off. I know that there are people who have done bad things, who are dangerous, and who need to be locked up. So don't get me wrong. I'm not one of those who says, oh, I feel badly for everyone locked up. So understand, just going in, we do need to have places where people who are a danger and will always remember a danger, and I've sentenced some of them, need to be. But at the same time, we are warehousing people who have mental illnesses, who have drug addictions. Now, again, prisons are where people have been convicted. They've been convicted of crimes. So the question is, what do we do about that? Where, by the way, the disproportionate number of those people happen to be people of color, Black and brown. So there's so much to be done. One is to build fewer prisons. And I believe that if we can divert some people who are in prisons, who have served time, who have drug problems, who have mental illness, to resources within communities to deal with them, that's what we ought to do. And even those who are in, who deserve to be in, who deserve to be punished, we need to clean up our act. I don't know if people have been to prisons. When I was a lawyer, I represented some people who were incarcerated at San Quentin. I have, by the way, also been inside the jails in Santa Clara County. And it's just stunning with how draconian they are and how much work needs to be done to make people feel that they are human beings, even though that they are incarcerated. Our prisons right now tend to dehumanize people, and that just has to change. And that means leadership. Wardens run prisons, and wardens get their marching orders from whoever the Bureau of Prisons, maybe who are above them. So we need to reach out to the leaders. And once we get leadership in that appreciates that people, even incarcerated, are human beings, and in many instances better than the worst things they've ever done, that certainly will bring a change in how we look at people who have committed crimes.
Jumping back to maybe more of a personal question, as you look back at your career as a judge, is there anything that you would possibly do differently now, if you could?
I appreciate the question. There's a chapter in the book where I write about drunk driving and write about what happened to me. I was hit by a drunk driver, and I couldn't go back to work on the bench for 8 or 9 weeks as a result of the injury that I suffered. And when I went back, I decided that it was important to do something different, because that drunk driver who injured me and destroyed my car just got basically a slap on the wrist and was back out on the road. So I became, as I write in the book, the first judge in the state of California to order convicted drunk drivers to put breath devices in their cars. In this book, I write about what happened, though, that the pushback I actually got sued. The district attorney came after me. Judges on the bench didn't want this. And I learned a lesson from all of that. And the lesson I learned was that it was important for me to communicate with my colleagues on the bench, to kind of bring them into the fold, to understand what it was I was doing, rather than just kind of operating, which I had the right to do on my own in the courtroom. But the big lesson I learned is that, and I think all of us watching this, I don't think anyone will disagree with me on this, systems resist change. If it's the schools, if it's businesses, it's like there's a way of doing things. We like it. It's predictable. It's comfortable. So when you have someone who's pushing it, saying, no, we need to change it, this resistance builds up. And that's exactly what happened to me every time I tried to bring change into the legal system. And that brings up the issue of judicial activism. I mean, it's usually seen as a pejorative, right? It's the judges who go rogue, who just go totally don't care about the rules, do what they want. I was a judicial activist, but not that kind. Judicial activism for me was following the rules, following precedent, abiding by the law, but using all of my time to figure out ways to make the system better. And I support that definition of judicial activism, and I do write about it in the book. Sometimes it worked, like in the breath devices, because now every state in the country allows or requires judges to use these ignition breath devices. But I also pushed really hard in the family court, and I did not succeed in bringing change to try to make it more user-friendly to people who could not afford to hire lawyers. And I write about that in the book as well.
Okay, now looking forward, how are you going to stay involved to kind of put some of your fix-it ideas in place?
So one way of staying involved was to write this book. It took me a year to write the book. I wrote every day for 5 hours. And couldn't have written it, of course, without the letters, which describe the various cases that my parents saved. And I don't think I got to that, but my parents saved all of those letters that I wrote. I didn't make copies. These were letters with a postage stamp, not emails, the real deal. And I think it's sad we've gotten away from letter writing in the age of social media. I'd love for that art to come back. My mother saved all the letters, and that's the only reason I was able to write the book. So going forward, I am, for example, involved in the San Francisco District Attorney's Innocence Commission. I'm a member of that, that's volunteer, to look at claims of people convicted out of the courts in San Francisco who claim they were wrongly convicted. So this Innocence Commission's purpose is to look at those claims and to determine if there's any merit to them and to make recommendations to the district attorney. I also just very involved just locally. I'm very concerned about whether or not the Board of Supervisors in Santa Clara County is going to go forward and build a big boulder jail in the county. And I don't think that that's the way to go. I'm more interested in looking at resources in the community to keep people from being involved in the criminal system and also to take those in to help them get the services that they need. So I, will continue to write opinion pieces and to speak out and do what I can to encourage people to vote. And that's what you all do. And it is the key. That's the key to our democracy. And I mean, it's just so glaring why there's been a pushback from Republicans, against, the voter suppression. I mean, it is the key to democracy. It's voting. And I'm just so concerned that about the suppression efforts. And, no one's going to give up. The League's not going to give up. We're all going to keep fighting to ensure that the right to vote, I hope, becomes a federal law so that these state laws cannot undermine our right to vote.
All right. And then the final question, which I think follows pretty nicely after that, is what gives you hope?
Oh, that's an easy one. There is no reason why anyone who is part of this conversation here should not have hope, because you are here. Each one of you are here, including me, because of what someone did before us to open doors for us, to get us the right to vote. We, all of us, stand on the shoulders of those who fought the battle. My maternal great-great-grandmother and my maternal great-grandmother were the enslaved. How in the world can I possibly complain about how things are when I know that there are people on whose shoulders I stand, who are related to me or even not related to me, who survived all of that to allow us to be here, one, to have this conversation and to hold the positions we hold. So it would be an insult to everyone who came before us for us to say, oh, I'm going to throw up my hands, I'm going to move to another country, or, just forget it, I'm just going to opt out. That's not an option. That's an insult to those folks. So we have to have hope. We have to. That's why we have come this far. And if you know your history, we have always had pushback, and then we push forward again. So we will do that. We must continue to do it. And I really think that that's what the League stands for. It stands for hope. It stands for saying we must go forward. We will. And I encourage us to continue to do that. And I leave you with what my mantra is. And I've taken it from Alice Walker, a great author, poet, social activist. And she said this, she said, activism is my rent for living on this planet. So I encourage everyone, pay your rent. Every member of the League, you always pay your rent. Thus continue, all of us, to pay our rent as long as we live on this planet.
Wonderful note to end on. Thank you so much, Judge Cordell.
Yes. Thank you so much, Judge Cordell.
Sure.
And thank you, Kathy, for managing this part of the program. We need a lot more time. And I'm almost tempted to say, do you want to stick around some more and continue the conversation? But I know that you're quite busy. we have more questions and we have some wonderful comments that came in for you. And if you don't mind, I will pass them on to you
That would
after
be
the
wonderful.
program.
Thank you so much.
And if there are some that you would like to answer, we could
Sure.
put questions and answers and distribute them to everyone who's attended the meeting afterwards too.
Fantastic. It's
Would that be
great
good?
because I see some of the questions in the chat. One talks about adoptions. I have a whole chapter in the book about adoptions, and it really is an answer to one of the questions that has been posted. So I would love it. I've seen some names with whom people with whom I'm familiar, and it's just great. So thank you all so much. I do hope that you will read the book and be energized to make our legal system the best it can be.
Thank you again. We will. And especially in the area of passing information about while the judges are being elected or up for retention, we have I think the league has just about the only place that people can easily go, which is votersedge.org. And we try to make sure that we have profiles of those up for the election. And we were definitely going to be looking at some of the reforms that you're suggesting.
Thank you so much. Thank you all. Thank you all. Take care and stay safe. Stay safe.
Our next Lunch with League is on February the 17th, and we will host Michael Ogilvie, who was the public art director for the city of San Jose. So just watch our newsletter for this and for other upcoming events. So I thank all of you for joining us today.